HMO licence fees and licence fees generally are quite controversial. Lots of landlords think that local authorities are making profit or profiteering out of fees. And this is kind of both right and wrong simultaneously. Clearly local authorities can't make a profit, they're local government, they're not businesses. But there's an aspect in which of course they could potentially be making money out of one area of business or one area of their work and then using it for something else. Now in fact they're not allowed to do that. The Housing Act 2004 is quite clear. Local authorities can only charge what it costs to run an HMO licensing scheme. Now at some level of course even then there's a bit of fudge factor, because if I employ 3 environmental health officers for the purposes of HMO licensing and to run the scheme, they'll probably do other bits of work as well. So there is a degree of overlap, but there's a limit to how far local authorities can go. In fact, in my experience actually, most local authorities actually subsidise their HMO licensing schemes, and in general landlords are actually roughly paying what it costs to run the scheme. It may seem a lot, but part of the reason it's a lot of course is that in a sense these are all little cottage industries. Local authorities all run their own schemes, and in practice they'd be much better off if they lump them together a bit more and centralise their administration, but that's not what local authorities tend to do. Now, things have got a bit more complicated because the High Court has looked at HMO licensing and fees recently and has interpreted something called the European Services Directive, which is something from the European Union. And what the European Services Directive says is you can only charge a fee that's appropriate to the cost of processing an application, whereas the Housing Act 2004 says you can charge a fee that covers the whole cost of running a scheme. But just because UK law says something, it can't do something that European directive says you can't do. So the difficulty now is that local authorities have been charging a fee which is meant to encompass not just processing a licence application, but all of the other work they do, like finding dodgy landlords and prosecuting and all of that stuff. And the High Court said they can't. So there are a couple of options around this. One is the nuclear option. We're leaving the EU in theory anyway, so we could just say, well, European Service Directive, bar humbug, we're not going to have anything to do with that. Obviously, that's going to make it difficult to have a trading relationship with the EU, but that's not my problem. It's a problem for greater minds than mine in a different department of the government. The second option is that it may be the case that you could charge a fee in 2 chunks. So you could charge a fee for the license application, and then if I get a license, I will have to pay a secondary fee for the rest of the operation of the scheme. And some local authorities are doing that. That's certainly compatible with the European Services Directive. It's not clear that it's compatible with the Housing Act 2004, which doesn't embrace 2 fees. The third option is local authorities just charge the fee for the signing of people up, and they're going to have to find some other mechanism of funding all the other enforcement-y stuff. Or in practice, possibly they won't do it, which is a bit counterproductive. Now, MHCLG apparently is looking at this issue and trying to decide what to do, but the jury is still a little bit out on this, and it's certainly the case that local authorities are going to have to look carefully at their fee structures and make sure they comply with the Services Directive. HMO licences can only last as a maximum of 5 years. So they can never be longer than 5 years. It is up to local authorities to set shorter time periods if they so wish, and there are 2 cases in which they can do so. They can either do so for everybody, so they simply say, well, we're only going to issue 3-year licences, or even 1-year licences in some cases. They have to have some justification for it. They can't just do it because they feel like it. And of course, if they're going to do that, there's an enormous administrative penalty for them, because they're going to have to process a hell of a lot more licence applications. But some local authorities have done that. They can, in principle, cut licence lengths for individuals where it's justified. But the upper tribunal has been very, very cool on this, and they can't just do it because they feel like it. And the difficulty with shortening a licensing length for somebody is there are lots of other powers local authorities have. So if, for example, one of the cases that came up was a person who didn't have planning permission for his property, and the local authority gave a shorter licence length, on the basis that they expected him to sort out planning within the year. Now the tribunal said that was fine, that was justified. But then somebody else had been prosecuted, and the local authority said, well, we'll give you a 1-year licence and then you can reapply for a full-length licence after the year. at which point you'll be rehabilitated. But that didn't make any sense, because if the person committed an offence during the licence, then they could just revoke it. So you have to have a justification that's very directly related to something about the property or the person. And merely saying, well, we think you might commit a crime, isn't enough, because those are things that can be dealt with by powers to revoke licences, so it would have to be something that was outside those criteria. So the position's a little unclear, and it depends on each case, but in general it's quite hard for local authorities to offer shorter licences to specific people unless there's something that they can't deal with by one of their other powers.